Hey, good afternoon. 540-0580. Carl Rominger back for a second hour of live legal questions getting answered here on the air. So if you have one, call in 540-0580. Whatever you want to talk about. Question about personal injury, divorce, wills, estates. Oh, what else do we want to talk about? Nursing law, I'll refer you to somebody else, as I did in the last hour. But, whatever you want to talk about. Want to talk about the court system? Somebody has a good story about something that happened to him in court. We always like those as well. What else I want to tell you? Because I'm going to be in Lancaster tomorrow. No, tomorrow's Sunday. I'll be in my office on Sunday. I'll be in Lancaster on Monday to try a case. So I'll be down there picking a jury Monday morning if the case is actually still on. There's a pending motion to continue floating around out there, but you never know what's going to happen with that. And that reminds me of something interesting that happens. It never ceases to amaze me. You go and you represent somebody in the court system, and you get from the government a series of documents and things and evidence. And there's these rules called discovery, and they're supposed to give you all this stuff. And then magically, right before trial starts, after you've turned down like 8 plea offers, suddenly 10 new documents appear. And I don't know, it just happened so many times to me over the years that I started to get suspicious and say, is it really possible that critical evidence always comes up after I've insisted that I'm not pleading my client guilty? I had one case one time where they, quote, found the 911 tape on the eve of trial. It had been lost and left on a shelf somewhere. And, of course, magically the 911 tape proved what my client was saying was true because you could hear what he claimed we should be able to hear in the background. And then you're like, wow, so you found it on the eve of trial. And, of course, then they dropped the charges. And you say, well, how can that happen? Anyhow, maybe I'm just cynical. I don't know. 540-0580. Serena.
Yes.
How are you?
I'm fine, thank you.
Thank you for calling.
Yes, I'm wondering if you have any advice for someone who's involved in a court case with a former partner who happens to be an ex-boyfriend and an attorney and is actually using the court to stalk her and not following court regulations on top of it. What recourse do I have?
Well, if the person's abusing the court system or abusing that, you could certainly complain to the judges of that court to see what they would do. Your other option is to the Supreme Court of Pennsylvania, to the disciplinary board if they're misusing their attorney position. And the other is just good old-fashioned litigation all by itself.
In other words, file a lawsuit against them?
Or whatever they're doing to you is counter it and point out where it's an abuse.
Right. Oh, but if you're in pro per, it's a little difficult to do that. He has money and he has a law degree and he practices law. Can I write a letter to the court?
Yeah, that would probably, if there's legitimately, well, let me put it this way. I don't know the facts of the case, and I don't know, sometimes aggrieved parties who think they're being unfairly targeted might be fairly targeted. So let's just assume it could be either or. Your first thing is you need to respond to any formal suit or thing that they do anyhow. You can't just let it sit, because in the American system, as with any legal case, if I file a cause of action that says that Shane stole my spaceship and I want $10,000 in damages and he doesn't answer it, I'll get $10,000 from the court even though I never owned a spaceship. I mean, that's just the way it works.
Right.
So you got to answer that. Number two, if there's, like I say, legitimately somebody's misusing their position as an attorney, that should be called to the court's attention. And the best way to do that is in your answer to the lawsuit, but also then you can go through the regulatory body that regulates lawyers, which is the disciplinary board of the Pennsylvania Supreme Court. And if you do the PA Supreme Court website, you can get there from there. And they have a complaint form you can fill out.
Okay. These are things like not notifying me of court dates, and I have to find out by checking the docket online.
Well, and that's interesting. Theoretically, though, they have to be giving you, the court should be sending you the orders and your address online. So unless he's certifying, he's sending them to you. And I'm just not sure what kind of case we're talking about, because court dates are usually shipped out by the court as well as the parties. So I'm not certain why you're not getting what the court dates are.
This case is actually in California, and I know that you practice in Pennsylvania.
Oh, well, see, there you go. I have no idea how they do things out there.
Yeah, the
See, I made an assumption.
Opposing counsel is required to notify the other counsel.
Right.
In this case, I'm pro per, and he's not doing that, and he's waiting to set dates until I'm actually traveling out of town, and he knows I'm out of town.
Right,
and,
right. Well, then you need to do one of two things, which is you need to call that to the court's attention, and you need to go to the disciplinary people out in California. But since it's a California matter, that's all I can tell you, Serena, because that's outside my expertise.
Absolutely.
All right, take care.
Well, I really appreciate your time. Thank you.
Not a problem. Yeah, remember, guys, I'm only licensed in Pennsylvania. Now, Steve in my office is licensed in New Jersey, and so is Eric. So we've got New Jersey and Pennsylvania available in the office. But as a general rule, I'm only going to talk to you about Pennsylvania law because every state is very, very different. Rick.
Hello?
Hello, Rick.
Hi. Good afternoon. How are you?
Good.
I got flooded out of my house. I rented. I rent. Yeah. Hold on 1 second, please. And, I was wondering what, if any, amount of time or anything my landlord's obliged to get me back into the house. I mean, I'm a paycheck to paycheck kind of person, and I'm already paid for my housing for this month. And, the last time this happened in '04, it took, quite a while to get things back into a livable condition.
Right.
And it's pretty much the same this time as far as damage-wise. It was about a foot higher, but it's very similar. So, I'm pretty stuck.
Yeah, the short answer is, obviously your landlord is in the same position you're in the sense that, they didn't ask for this. Best thing I can tell you is they should have duty to repair it as fast as possible. If they don't, then you'll be considered constructively evicted. Meaning that you can break the lease and move somewhere else. But that would be my best advice is, just make sure they're moving as fast as possible. Hopefully the landlord had insurance, etc.
Yeah, they said they do this time, so hopefully it'll be a little quicker than last time.
Right. And, of course, here's the problem we have, which is, there's only so many contractors and handymen, etc., floating around the area, no pun intended. And so it's going to take a while unless you happen to be first on somebody's repair list.
Right.
All right, my friend, that's the best I can tell you.
No, it's horrible. I'm camped out in my buddy's living room, me and my dog.
Well, at least you got somewhere to stay. That's the good news.
Yeah, it's tough.
That's what friends are for, brother. All right, man. Talk to you later.
Thanks.
540-0580. I'll see you after the break. (540-0580) talk line number. If you have a legal question, jump on. Whatever you want to talk about, divorce, custody, family law stuff, spousal support. Actually, I was talking to a colleague recently who had a case involving spousal support where one of the parties was employed under the table. And, of course, it's how do you prove it? How do you prove that somebody's employed under the table and how much they make? And it gets to be problematic because good proof is hard to come by. You could try to figure out who their customers are. Even if you might know. I had a case one time involved babysitting and that sort of stuff. So, the husband had some ideas of who the customers were, so to speak, so we could at least kind of round up some estimates. Other times you have somebody that's like a self-employed cleaning person who is, quote, working under the table, and how do you prove how much cleaning they're doing, where they're doing it, who all their customers actually are. And a lot of times one spouse doesn't really have perfect knowledge about that. It always makes for interesting issues. I know waitresses and waiters are another famous area, too, when it comes to tips. We always fight those out in support court as well. 540-0580. By the way, tip, get the banking records. Jeff, you're on the air.
Hey, how you doing, Carl?
Good.
Hey, I have a landlord-tenant question for you.
Shoot.
I have a tenant that had a dog. She's left now, but the dog has, there's urine stains on the carpet, and I was wondering now the carpet wasn't brand new, but at the same time it wasn't stained or anything like that.
Right.
I was wondering, do I have to, how do I handle that? Do I have to take into account depreciate the carpet, or what's the rule?
Yeah, you got 30 days to send him an itemized list of damages and money you're withholding.
Right.
So to the extent maybe that you could clean it, if you could clean it, with a steam cleaner or special service, etc., you certainly could go after them for that amount of money or withhold that much. Do you have a security deposit?
Yes. Now, she's had it cleaned before, and the stains will come up. I have a really good carpet cleaner, but then they come back. So it's kind of one of these. I'm not sure that I can charge her for the full amount of carpet, or I'm not sure.
If you replace the carpet, theoretically, if you have to replace the carpet, you could go after her for that. Yeah. Now, the question is that normal wear and tear? So that's an interesting question. Are stains in a carpet normal wear and tear? Well, over the life of a carpet, I guess we would expect there to be some stains or issues, right?
Right.
Is it a 5-year carpet, 10-year carpet, 15-year carpet? I don't know. But if we knew what the lifespan of the carpet is, if you're close to the end of the lifespan, I think you could make an argument, though, that a dog stain or something like that is not just incidental and normal wear and tear. That's a discrete damage that she could have prevented.
Right.
So I think you could go after him for the value of replacing that carpet.
For the full value of the new carpet, or do I have to depreciate their...
I think that's discretionary with the court as to what your damages are. It seems to me you're right, though. I guess if you were 10 years into a 15-year carpet, and so theoretically to pull it up in 5 years anyhow, and you're going to replace it with 15-year carpet, if I were her lawyer, I guess I'd argue that, well, she should only pay for the last 5 years of that new 15-year carpet.
Right.
But
at the same time, I would argue the fact that, well, I can't rent it out with urine stains on it.
Right.
And there was no stains before.
Exactly. Now, of course, then you run into these arguments, too. Here's the next one. Are you ready? Because I had this before. So I represented a woman who had been injured, and then because of the injury, she had bled on her carpet, okay? And they had to replace the carpet. It was white carpet. But as she pointed out, the carpet in the one room matched the carpet in the 2 other rooms, and of course, in order to make it match, we had to replace all 3 rooms. You sure heard the insurance adjuster guffawing at that.
Right. Yeah, unfortunately, this is in every room. I mean, if it was just one room, it wouldn't be so bad.
Oh, every room. Oh, man, you got to do something. That's not normal wear and tear. That's a bad tenant.
Right.
That's a bad tenant.
Right.
All right, my friend.
Carl, thank you. I appreciate it.
Make sure you send that itemized list of damages right away while you're retaining the entire security deposit, and you can sue her for surplus if you want, if you have extra damage.
Okay.
All right, my friend.
Thank you.
540-0580. James, you're on the air.
Hello?
Yes, James.
Yes, how are you, Carl?
Well, I'm good.
Good. I'm glad I didn't say that to Dr. Savage because he don't like to be asked how he's doing. I listen to 580 all the time, and I have a close friend of mine who has been a caretaker of a man who's been in the same dwelling for 26 years, I believe, and she's been there for the last 12. And she's changed his diapers, and he was in a wheelchair, and now he's passed away. And as soon as he passed away, the landlord gave her an eviction notice, and his bank froze up all her assets. Now, I don't know. She says they exchanged rings in the hospital, but M&T has closed down frozen his accounts, and she really doesn't make anything. So what type of procedure would you have to go to free up some money for doctor bills and stuff like that?
Well, that's an interesting question. So she's saying that when this guy died, that she's his wife?
Her brother-in-law or whatever he was a preacher, but there was no formal documents filed at York
at the courthouse.
At the courthouse.
Right.
So they just exchanged rings right there, and he said he really didn't want to get into it because they didn't. He didn't.
Yeah. So they probably aren't actually married because there's no common law marriage anymore. Although there was an actual exchange of rings, but that would still be common law because you're not doing it through a license. So seems to me is that there's no marriage there. So the next question is the money in the bank accounts probably belongs to the estate of the guy who died, so it has to flow through that direction.
Right.
So whoever the heir of that person is needs to open an estate.
Okay, well, his heirs are not even in contact with him for the last 20 years.
Right. Interesting.
Yeah, and she's really in a bind.
But she's a caregiver, and maybe he owes her money, which would make her a creditor, and she could open the estate from a creditor's standpoint.
Okay, Okay, now what do you mean by that?
In other words, she would say, okay, I worked for this guy, I helped take care of him, and I'm owed money for the time I've spent and the effort I've done. And since the estate, nobody's opening the estate, but I'm a creditor of the estate, I'm owed X dollars, I would like to open an estate, Judge, and get paid.
Open an estate.
Yeah, a creditor can open an estate as well as an heir.
A creditor.
But it just depends how much money we're talking about and whether it's worthwhile or not, whether it's
actually, it's about $270,000.
Okay. So it's definitely something that would be worth pursuing. The question is, how much of that's she actually entitled to? We'd probably want to sit down and go over some other stuff with her that we can't do on the air just to see where we're really at.
Well, could she give you a call?
Absolutely.
Is it the same number?
241-6070.
241-6070.
Yes, sir.
That's 717, right?
Yep. That's our office number.
Okay, and your name is Carl.
I'm Carl, but and a couple other lawyers in the office do estates as well.
I'm sorry?
A couple other lawyers in the office do estates as well.
All right, thank you very much.
All right, my friend. Take care.
Bye-bye.
540-0580. I don't know how that one's going to work out. Who knows? Zach.
Hey, how you doing, Carl?
Good. What's going on, brother?
Hey, I had a question for you. I have some friends that actually they live in Manhattan, and they said that like right now they just have like mandatory checkpoints all over the place. Like they're searching vehicles, but you can't say no.
Right.
I mean, last time I checked, this was the U.S., not Nazi Germany. I mean, can you refuse those and then, just have to go to jail, or do you know anything about that?
Listen, here's the answer. The Fourth Amendment says that you can be free from unreasonable searches and seizures, okay?
Right.
And the courts have said that an unreasonable search or seizure has to be remedied or weighed against the harm sought to be dispelled. So, for instance, there is no such thing as a warrantless entry for a noise violation, okay? So the courts have basically said if somebody's playing their radio too loud and you can't get, they won't answer their door, you can't just enter because of a noise violation. That minor summary ordinance violation does not create a right of entry because the Fourth Amendment balances out against it. So let's flip it around and say the police are there and they hear screaming and it sounds like somebody's being tortured. We would say that a warrantless entry under the circumstances, as the exigency of the circumstances, warranted, okay? So under one case, we say, just to turn down somebody's radio, you can't make a warrantless entry. To stop a woman from being tortured or raped, even if that's not actually what's going on, you're just actually watching a Rob Zombie movie in there and you're just refusing to answer the door, and the police come in and they see your cocaine, the judge is going to say, hey, he heard people screaming, he didn't know you were watching House of a Thousand Corpses and really loud, and so he gets to keep your coke and you get to go to jail. So that's kind of how that balancing test works. So now let's ask it this way. We now think that there are terrorists with explosives driving around New York trying to detonate them between now and sometime tomorrow. You start to do the weighing out and you say, well, the government might win that one on a Fourth Amendment analysis. Now, on the other hand, there's a bigger idea here, which is if you give the government too much flexibility, right, then they can always just manufacture a reason, because there's always a threat of terrorism. There's always a threat of immediately of somebody having, every car in New York could have explosives in it. So it's going to have to be weighed out. And the short answer is, I suspect on the short term, if the FBI comes forward to a federal judge and somebody else comes forward and says, I want you to restrain these guys from these random searches of everything, the judge may do it unless there's some credible evidence, and they may show him something and say, here's what we got, we were beating this guy with rubber hoses here, and here's what he told us. And then the next question is that credible information or not, or who obtained it and where, or a lot of times the government doesn't even want to tell you what they actually have. In fact, I just saw a guy that pled guilty in a federal court. He's going to be sentenced, and the judge is like, well, whatever he took was probably really important, but I don't know what it was.
You're not talking about the guy who had got the life sentence for recording the police, are you?
No. This was a guy who gave secrets to Israel, spying on the U.S.
Well, he was just following Clinton, because Clinton gave secrets to China, so I guess he was just
well, see, that's the difference. When you're the executive, you can give away secrets.
Right? I know, I was being...
No, I know, but I'm saying, isn't that funny when it's great to be king?
Yeah.
King for a day. By the way, do you know the only difference between a president and a king, right? Currently nothing. Currently nothing, because in the United States, Congress doesn't even vet when the president wants to go to war anymore, right? It's not since Truman or whatever. So we do essentially have a new king every 4 years and sometimes for 8 years, because we have now given the presidential power to the point where they literally can act like a king because they have the power over life and death without congressional.
Well, I'm extremely concerned right now because even though I thought Bush was a terrible president, and he was, he even got somewhat permission from Congress. Now we're in complete violation of the War Powers Act, which still doesn't substitute for a declaration of war.
That's right.
I mean, that's insane.
And we've been listen, and you're unpatriotic when you question it, right?
Yeah, you're either with us or with the terrorists. You can't be in between to say,
hey, I'm with Dick Cheney. I want to bring Hillary Clinton back.
Yeah. What those are two mental midgets. How about it?
Well, I can't. It's just that's one of those funny things where you're like, really, Dick Cheney really wants to bring Hillary Clinton back, but actually, I think all things being equal, I agree with him that she would be a better president than the current president. But what do I know? All right, my friend, I got to let you go because I got to go to break.
Thank you.
Thanks, Zach. 540-0580. Hey, welcome back. Carl Rominger here. I'm going to be at Shooting the X in Carlisle next Saturday, broadcasting live from 1 to 3. And they're going to have all kinds of stuff going on out there. I guess there's a shoot going on. They have these new archery center with these moving targets. And so I'm going to be out there practicing a little bit this week, I hope, and getting ready because supposedly Dan, the owner out there, wants people to shoot against me for prizes. And I was like, dude, you better get rid of a lot of prizes to give away, because shooting against me is like shooting against well, let's just put it to you this way. The odds of you beating, if you have a bow and you've used it more than once, the odds of you beating me are 50-50. And if you shot it at least 3 times in your lifetime, you're probably going to beat me. Well, I might be a little better than that, but I don't know. Come out and see. So I'm going to have my bow out there. I'm going to do a little shooting, but obviously I'm going to do the show from 1 to 3 live. You can ask questions live. It'll be just like we did down in Lancaster. But it's going to be a great... So if you're a hunter, a fisherman, bow hunter, waterfowler, you might be familiar with Shooting the X on Allen Road in Carlisle. I'm going to put it up on my Facebook page. We'll pump out some more information. But make sure you swing on by and check it out. I know they're going to have a lot of good stuff on sale. And like I say, they're going to kind of make a mockery out of me. So bring your bow along, and we'll see how you do. 540-0580. Dan, you're on the air. Dan.
Yes, hi. The question I have is this. Let's say that I buy a vacation house here in Pennsylvania, but I leave the state to accept work. It could be in another state, another country.
Okay.
As far as Pennsylvania state income tax liability, am I still considered a resident?
Your domicile controls where you're a resident. So if you bought a vacation home here, or you bought a home here that you're making your vacation home and you're going somewhere else to live, the big question is, where do you intend to return to? And so that would be the general analysis.
Okay, thank you.
All right, my friend. I think that's the right analysis. Here's the other question. Like, okay, yeah, I've got a house in Idaho and a house in Pennsylvania, and I'm intending to return to neither, so I don't want to pay state tax in either. Why don't you just move to Florida? I don't have any down there. 540-0580. That's why Rush Limbaugh is down there, by the way. Marty. Hello, Marty.
Oh, hi, Carl. How are you?
Good.
I have a question on if there's any time limit to a division of property and a divorce settlement. What happened was about 18 years ago, my wife, who was married to her ex about 18 years ago, they got divorced, and they basically shared the furniture.
Mm-hmm.
Her ex had a lot of medical problems, and he just asked, like about 3 years ago, for the furniture that was his in the divorce decree. Is there any time limit on that, or did she have to give everything back to him that was his legally?
Theoretically, there's no time limit on it. I guess at a certain point you could say, well, detrimental reliance. I thought, I had this stuff available for you. You never claimed it. It took you so long that I've relied on it. The other concept would be something called latches, where you would say, Latches is this concept in the law. Don't ask me where the word comes from, but it basically means you could have done something, you didn't do it, and now it's too late to ask to do it. So a great concept of latches is I loan you my lawnmower, and I show up 20 years later and I say, give me back my lawnmower. And you say, well, I just thought you were never asking for it back. And after 20 years, I thought I was reasonable in believing that. So you no longer have the right to assert that. So that may be a potential defense as well. And I got to imagine, is the furniture all still there?
Oh, no, he passed away, and she gave him the furniture because she didn't want to really cause any problem, and he was a little unstable, so she didn't really want to, get into anything with that. But I was just wondering after the fact if there was any legal recourse she could have done.
Yeah, I mean, there's some arguments there. The problem is you're going to basically end up at the mercy of whatever judge you get. And some judges are going to be like, hey, you waited too long, and kind of buy that argument. And I can see another judge going, hey, an agreement's an agreement, and it took him a long time, but he had some health problems, and now you don't want to turn his stuff over. So not only am I going to make you turn it over, but you got to pay his legal fees.
Oh, okay.
Depending on what the agreement originally said. So,
yeah.
All right, my friend.
Okay, thank you very much.
No, interesting question.
Okay, thank you.
Let's see, 540-0580. Will, you're on the air.
Hello.
Yeah.
All right, Carl, I've got a stickler of a question for you, and I don't even know if you'll answer this one.
I don't know. I never know.
Okay. I am a subcontractor for the U.S. Postal Service.
Okay.
I haul mail. I haul treasury, that nature. Sometimes it's high dollar. Sometimes it's just run-of-the-mill bulk mail. Never know what it's going to be. I haul all different routes, but this week I'm actually hauling routes that take me through New York City.
Okay.
I've been driving around New York City, but just to avoid the whole mess. But there's always a chance that somebody's going to pull me over because right now they're lining all the trucks up, breaking the seals, looking inside all the trucks.
Right.
If I break that seal, it's a felony.
Right.
The only people who are allowed to break that seal are the U.S. Postal Service and, I believe, the Secret Service. But if I don't follow the instructions, if I don't break the seal, as I am told to by the Transportation Authority, I'm pretty sure they can arrest me for that.
Yeah, well, this puts you in one of these conundrums where one agency's telling you to do something and the other one's telling you you're going to go to jail if you do.
Right.
And
now,
so,
the only thing I can think of is to say, listen, you're not breaking, because if that seal's broken,
right.
If I break the seal, it's a $5,500 fine minimum. I'm sorry, go ahead.
My thought on the matter is this. It is a defense that when you committed a crime, you were instructed to do something by a government official, okay? In other words, there is a defense available where basically if you go to the court and the judge says you've got to do this, for instance, and you do it and somebody else charges you with a crime and you did it under court order, let's say, or or the advice of the clerk, that can become a defense. Or if a police officer tells you, yes, you can do this. Now,
doesn't help me a bit.
It's not the Nuremberg defense either, though, so you can't you can't say, well, they told me I could do this and I did that, and so I shouldn't be in trouble. But I guess what I'm trying to tell you is, generally speaking, we also have another concept out there called prosecutorial discretion. And that means that not every, and I've had some yahoos on with me on the Durgan show from time to time who insist that every law must be enforced, okay? And that the president's a communist if he doesn't enforce every law and blah, blah, blah. But there's lots of laws in the books that aren't enforced. And there's lots of laws that are only selectively enforced. And it's quite possible that the good district attorney or the regulatory body or whoever would usually prosecute you for breaking the seal, or the Postal Service or whoever would say, you know what, technically, yeah, you can't break the seal and it's not a defense. But we had kind of a national emergency. We had credible terrorist threat and you were ordered to do so by, fill in the blank. So we're going to decline to hold it against you or prosecute you. That's your other out.
Well, I had a thought on how to proceed if I ran into that situation, and I don't know whether it would be defensible if they decided to prosecute me anyway.
And I'd be happy to represent anybody I could whose only crime is that they broke a seal because they were being asked to prevent a terrorist threat against anybody who was dumb enough to try to prosecute him.
Well, my idea is, since the U.S. Postal Police are the only ones who are authorized, other than Secret Service, to break that seal, is to stand in front of the seal and say, listen, I'm responsible for this load as long as it's attached to my truck. You called the USPS, and I'll stand right here, and you called the U.S. Postal Police, have them come down here and break the seal, and I've got no problems. But if you try to break this seal, I have to try and stop you. Yeah,
you don't have to try and stop them. You just have to say, I'm not going to do it, and if they want to break it, I don't think you have to stop them.
If they break it, I'm still responsible for the seal.
Yeah, I understand that, but you're not allowed to use force on a government official, and you can't. You're going to get in trouble. So my advice on that one is you say, hey, I'm telling you not to, but if you're going to break it, you break it, and understand that I might get in trouble for this, but I prefer you call these guys first, and I think that will solve your problem at the end of the day.
Okay.
And if they find the explosives in your truck, then you'll be really happy that you let them break the seal, right?
Yeah, there you go.
All right, my friend. Yeah, you can't, listen, here's the end of the day is, and I understand all these setups and issues you can come up with and conundrums. Usually you're not going to get prosecuted. Usually everybody's going to exercise their discretion. And when they don't, that's when I get to come in and hammer them, all right? Because the reality is most judges and most regulatory bodies are going to go, wait a minute, you're prosecuting this guy because he did what he was told to do to help prevent a terrorist attack. Okay, not guilty. Cindy, you're on the air.
Hi, Carl. I was calling in regard to an accident, a car accident that happened a few months back. A member of my family was involved. They were hit by another vehicle, and there was a lot of alcohol present.
Mm-hmm.
And I was wondering if there is a specific protocol that state police generally follow when there's alcohol at the scene of an accident.
Well, I mean, if there's a lot of alcohol present at the scene of an accident, that would give them the gist that somebody was drinking. So usually they would want to check the drivers to make sure that they were sober.
Okay, that was my main question, because my family member was the one who was injured. They were hit, and the other driver that was carrying cases of alcohol was never checked at the hospital.
Right. And there may have been no reason to believe. Let me explain it to you this way. I mean, I just had 3 cases of beer in the back of my pickup truck. It doesn't mean I was drunk, does it? I mean, so that's the question. I mean, where was the beer? What condition was it in? Were there open containers? If I have 3 cases of Sly Fox floating around the back of my pickup truck, but they're all closed containers, I doubt the police are going to assume I was drinking one in the front cab. On the other hand, if there's 12 empty Sly Fox cans in my passenger seat, and one sitting in the cup holder, they're probably going to assume I was drinking and driving at the same time. So, while there's a general protocol, I guess it would depend on what was present from the officer's standpoint. Now, the next question is, what difference does it make whether the guy was drinking or not in terms of causing the accident? If he caused the accident, he caused the accident. And, of course, if your family member had limited tort, that's the only time they'd really care about whether the police investigated the drinking or not, because that's one of the ways you can get around having limited tort status if you're injured.
Okay.
But hopefully she has full tort like everybody in Pennsylvania should have, because limited tort's a ripoff.
Correct.
I got to go to break, Cindy.
Thanks so much.
All right, thank you. 540-0580. Hey, welcome back. Just a reminder, I will be at Shooting the X next week from about noon to 4. We'll be broadcasting live doing this show from 1 to 3, so you can call in as always. And Holly Love will be there, too. So if you're a Bob FM fan or just a fan of Holly's from this show, you should come on out and see her as well. Always great to have her along. Of course, she will be telling me what to do the entire time and reminding me about all my cues. Holly is very good about that. She's very helpful. That's the word that I think she would prefer I use. 540-0580. Andy, you're on the air.
Hi, Carl. Thank you very much. I appreciate your program. I have a question regarding a traffic citation that my daughter received. She feels that it was not correct, and regardless of whether of that, how does she go about asserting her opinion? Does she wait till somebody she's got a citation? Does she go
says
to
not
the
guilty.
magistrate? What does she have to do to initiate a rebuttal thing?
Well, the only way you well, first of all, she's a criminal defendant, okay?
Mm-hmm.
So criminal defendants don't rebut what the government does. The government has to prove what they want to prove their case first, okay?
I always thought she was a criminal, but that's another
Now you have proof. So you have her plead not guilty. That sets up a hearing.
But, I mean, do they send something to her and say, you have to pay for this within 10 days?
She should be getting something, but the citation on the back allows for that as well.
Oh, okay.
On the top of there's a sign not guilty on the back. You send it in to the address on the front to the magisterial district. They'll set up a hearing. At the time of the hearing, the police officer has to come forward with the evidence of the violation, and then she's free to present whatever she wants. Mm-hmm. Now, keeping in mind one thing, though, anything she says can and will be used against her, right? So sometimes it's good to have a mouthpiece there where I can ask the questions, I can say the things, and I can make the arguments, but she's not saying anything or getting trapped into something. The good news is after she loses in front of the judge, if she does lose, is she has the right to appeal it to the Common Pleas Court for a redo. If she wins, it's all over.
Right.
All right?
Okay, and so what she should do is call your office and
we'd be happy to help her out.
Details to your people and find out the costs.
Exactly.
Kind of
a couple hundred bucks, she can get a lawyer in court with her. And the answer is depending on what the citation's for. And the other thing I always counsel people, quite frankly, is they're like, well, I only got one speeding ticket, so I wasn't going to fight it. But then they come to see me 2 speeding tickets later, and I'm like, I could have won 2 out of 3 of them, but now you were going to make me win 1 or else.
Well, the way she tells it, it was a stop sign thing. The way she tells it, she stopped. But that wasn't even the big thing. It was the officer was apparently from, again, her thing. I wasn't there. Very over the top, so on and so forth. And she said, well, I don't think I did this. And he said things like, you're going to fight me? Who do you think? How do you prove that stuff in court? I mean, I don't know.
The short answer is, is it possible it went down that way? The answer is absolutely yes. I've had the pleasure of being pulled over by a lot of officers, and I sometimes I sometimes find them to be gentlemen or gentlewomen. And I've had a few yahoos. And over the years...
She was actually shocked. She couldn't believe it.
Well, over the years, I've developed a short list of people where, listen, I can't have 27 clients tell me the same story and not start to think, people who don't know each other all say, like, this officer is just screaming his head off. And you're like, well, it's strange that 27 different people over 10 years all experienced the same screaming.
Yeah, and then presumably, again, I wasn't there. He threatened her with, I don't know, I'm going to give you a 4-1-1 something, which will get you 4 points, or I can give you a 3-1-1 something.
Right.
If I don't have any idea, and whether that actually happened. All I know is that it's what she said, and that's the way she said he approached it. So.
Right. Well, you're right. Just a question, but you know what?
Just need to call your office and go from there.
241-6070, okay?
Got it.
All right, brother. Take care.
Thank you very much. Take care.
Let's cut him off too short again. Nick, you're on the air.
Hello?
Yes, Nick.
Yeah, I'm broken record. Thanks for being here, Carl. I just wondered about my tenants' rights. I got evicted, put in the hospital. A month later, they got my stuff out, and I never contacted PP now. So I was charged about 4 or 5 months electric. And is there anything on the books or anything I could find in black and white to prove that, saying that after a month I'm not liable for my electric? And
there's no law on that per se, but again, I think that if you were evicted from the date your eviction, get your eviction notice and give it to the power company. All right,
I did, but I told it and everything, but then they denied it. Now I'm coming up for a hearing.
Well, when you have your hearing, I would take the eviction notice along from there, and you might want to think about getting a lawyer to take to the hearing. All right, my friend?
All right, thanks, Carl.
Yeah, that's no good. Alan, you're on the air. Alan.
Yeah. Carl, are you there?
What's going on?
I got a question. Condo was built 15 years ago. all of a sudden there are real defects to a contractor to blame. The contractor is bankrupt and dead. Is the condo association liable in any way for what the contractor did?
Probably not. Probably not. You got the statute of repose against the original builder potentially. Then you've got the fact that they're a deceased entity, and the association is probably an independent entity that was created to manage it. But I don't think that they would be responsible. But if you really, if we're talking about serious problems with the condo and a lot of money, it might behoove you just to run this by Steve Snyder in my office.
Well, that's what I want to know. I'm trying to prevent the association from being liable for that type of stuff.
Yeah, I don't think they are liable.
Okay. Hey, thank you much.
All right, my brother. Yeah, but that's one I would definitely get checked out because you're talking about big bucks. That can be an issue. But I don't see how the association would be next in line. But then again, we'd want to see about their incorporation and their charter and all their rights and responsibilities in these source documents. Neil.
Yes.
What's going on?
Oh, I'm looking to help a friend of mine. His property is going to be going up for tax sale, and if we're the successful bidder at the sale, what has to be done to get a marketable title on that? Like, how do you clean a title up from a tax sale?
Well, yeah. The short answer is you can take marketable title out of the tax sale, but you take it subject to any and all liens that are on there. So if he owes a mortgage or anything like that, then you become responsible for whatever the liens and things that belong to the property. At a judicial sale, which happens when it fails to sell at a tax sale, then they would push it up to a judicial sale. It gets free and clear of all liens. So usually what we would do, if a client says to me, I'm buying somebody at tax sales, we'd do a full title search on it. And if there's a cloud on the title, we'd say, you're taking it subject to that cloud. And if the guy owes a mortgage to some big bank somewhere, you're also taking it subject to that mortgage, et cetera, et cetera.
Well, other than the liens, it was in the family history, it was a grandfather. They died. They had a will. It's like, their parents have it now. So does any of that factor in?
Yeah, a tax sale doesn't clean up the title issues at all. So you get it the same way it is as it is now. And so that's why we would usually do a full title search to look for any issues that we basically say, well, this guy can't pass good title anyhow, or he can. And if he can,
how do you clean that up if there's a break in a succession?
Quiet title action.
Quiet title action. Okay.
Yep.
All right.
All right, my friend.
And you guys do that?
Absolutely.
Too? All right.
All right.
Thank
Steve's
you.
the best guy in my office to ask for that particular area as well, by the way.
Who's that?
Steve. He was on a little earlier with me.
Okay.
All right.
Thank you.
Just a reminder again, I will be at Shooting the Axe on Allen Road in Carlisle next week. I'm going to have my bow and arrow there so you can make fun of me. More importantly, I'll be doing the show from 1 to 3 so you can stop in and meet us. And I think I'm running out of time, Kevin, so I'm going to have to let you go. Kevin, just call the office or go shoot me an email from romingerlaw.com and I'll get to you. But again, I'll see you guys live next week out at Shooting the Axe on Allen Road in Carlisle. Thanks for listening. It's been a great 2 hours, great questions as always, and glad to talk with you.